The mediator has a definite role to play in mediation. Mediation depends on the mediator. Mediator's qualities are very important, and therefore, the result of mediation, depends on the mediator's skills. He has a definite role to play. Firstly, mediator is not a judge. He is not deciding anything. He is not an adjudicator saying that this is right, that is wrong, or A is wrong, B is right. These are only for a judge or an adjudicator or an arbitrator, not for a mediator. Mediator may be a retired judge, an advocate, but when he is wearing the hat of a mediator, he is not a judge, he is not deciding anything, he is not even thinking as a judge. His only role is to facilitate. He is not supposed to advise. He is not supposed to advise the parties or even give an opinion. He is not a consultant. He may be sometimes in a given mediation, it could be that a party is a doctor. That could be the dispute between the two parties, could be the medical negligence, where one of the party is a patient, the other party is a doctor, and the mediator could be a third party neutral senior doctor who is sitting between the parties to mediate and find a solution. But he is also a doctor by profession. But please note, when he is a doctor, when he is a mediator, he is not a doctor. He is only a mediator to facilitate. His views, his expertise on the field cannot be brought in there between the mediation sittings, during the mediation sittings. The word mediator has been loosely used. He is not a broker. He is not a middleman. Mediation is a scientific process, and a mediator is appointed by the two parties who have faith in the whole system of mediation, and the mediator appointed. He cannot be compared with a broker or a middleman, which is usually used in a real estate transaction or in marriage. It is not the role of a mediator, the mediator role is not the same as a broker or middleman. Mediator is getting the qualification after a certification, and therefore it cannot be compared to a broker or a middleman. Do not try to convince. Do not suggest. Do not say that this is good for you. This is not good for you. This will not help you. Do not say what are the good effect or bad effect of a solution, or not getting a solution and continuing with the conflict. It's not for the mediator to forecast. Very importantly, as I said earlier, mediator facilitates. The facilitation is by a communication process. We recollect A is a sender, B is a receiver. Similarly, mediator is a receiver sometimes, he is a sender sometimes, and in the process he facilitates the parties to know and take their decision. He also helps the parties to evaluate. Please note, in facilitation, he directly facilitates. When it comes to evaluation, he is not evaluating himself. He is helping the parties to evaluate. That is to say, the advantages or disadvantage of a settlement are put across to the party, and it is a party who says or decides as to what is right for him, and he tries to help the parties in finding a solution through evaluation process. In other words, the mediator activates the thought process of the party by making the party to think, and the party starts thinking the merits and demerits of a mediation and the possible outcome in the mediation, and evaluates with the present situation, and if he sees that there is a benefit in the mediation and the solution, he would definitely take the solution and try to get the best out of that. If not, he is always free to walk out of mediation, and he can always say, no, I think the continuation of mediation may not be fruitful and it may not help me, and I would therefore continue to go back with a conflict and resolve elsewhere. Right to agree or disagree is purely in the control of the party. It's the party who decides whether he would like to agree or disagree. It is not the mediator who is supposed to suggest, saying that this would result in this, therefore agree or disagree. It's not the clear role at all of the mediator. How do you achieve the activation of the thought process between the parties? Maybe this is one of the ways. Enable the parties to find the benefit of definiteness versus indefiniteness. Definiteness of a solution in the mediation right now or right today versus indefiniteness of continuation of conflict and which may not end in the near future. So when the definiteness and indefiniteness is evaluated to the party starts thinking, his mind process, the thought process starts thinking to, and also to see what would be best in his interest. If he is of the opinion that a definiteness is better, he would definitely take the opportunity and try to move forward in mediation. I repeat, the parties control the outcome of mediation. It is not the mediator. It is only the parties who take the final decision, and the mediator is only controlling the process. The example which was given, the car is owned by a owner. The mediator is only the driver of the car. He is licensed. He has been authorized to drive, and the owner says, please take me to the destination, and the mediator as a driver of the car only takes the owner to the required destination. Whether to go on the left side of the road or the right side of the road, at what speed he has to go, where he has to stop, it is a domain of the mediator, and therefore mediator only controls the process. The party, namely the owner, decides where to go, how to go, and the mediator helps by driving to the destination. Usually the parties during the process of mediation ask the mediator, sir, don't you think that I was right? Don't you think that the other side was wrong? For a mediator, it is immaterial. Mediator is not deciding or taking any decision. Mediator is not seeing who is right or who is wrong. Nothing is right and nothing is wrong. It's only the context which you have to see. But for the party, he is always in the mold where he is wanting to know whether he is right or he is wrong. It is for the parties to decide. As we said earlier, it is only the perception which you have to see, and the parties have to go forward and accept and realize that what is coming in their presence, what is the outcome which is likely to come, and take a decision. Right or wrong is immaterial for a mediator. Mediator enables the parties to see a solution. In a mediation, the solution is possible only when both parties feel that they are in a win-win situation. If a party is feeling that he has a better chance outside the mediation and that he is not likely to get the best result in the mediation, then it is not win-win for him. So therefore, mediator has to see that both parties have the feeling of a win-win, and then only the mediation can proceed and the parties can get the required result. Mediator can focus the parties towards certainty and peace. Peace is ultimate. When the parties get peace, or achieve peace, it involves and includes justice. And it also gives certainty, because in a mediation settlement, the the conflict is resolved and there is a certainty. Whereas in litigation or other forums of mechanisms, other legal mechanisms, there is no certainty, because there will be uncertainty which is lingering all the time. And therefore, mediation succeeds only if there is certainty and peace. And when that is conveyed to the parties by way of evaluation, the parties think that this is a win-win situation and accept to go forward and find a solution in mediation. Agree to agree is mediation. Agree to disagree is also mediation. In agree to agree, the mediation proceeds with a final memorandum of settlement which will be drafted between the parties, or it could be a recording of an agreement which will result in the final outcome, putting quietus to the conflict. In agree to disagree, there is no possibility of a settlement. But even in a disagreement, there is a serious agreement. Probably that serious agreement is that they have a serious difference and therefore they cannot agree at all or compromise at all. It may not result in a settlement, but definitely it helps and focuses the parties to achieve their desired result in another forum or an alternate forum, and they are more focused. And probably also sometimes this helps to narrow down the scope of the conflict and helps them to focus on what exactly is the requirement of the parties. Sometimes it could be agree to partly agree and partly disagree. This is also possible in mediation. That is to say, in some conflicts, there are two issues, issue 1 and issue 2. It could be that both parties are agreeable on issue 1, but they have a serious difference on issue 2. Now, issue 1, there is agree to agree. They can arrive at a solution and draw a settlement. Keeping open issue 2 or deferring issue 2 to the parties to go for an appropriate remedy before an appropriate forum. So agree to agree is possible, and that agree to agree can result in a settlement. I would like to give one example here to understand this concept of agree to partly agree. There is a landlord, there is a tenant who occupies a portion of his premises. The landlord wants an enhancement of rent for his premises. The tenant is not agreeing to pay that enhanced rent. The landlord also wants eviction of the tenant from the premises, but not immediately, after 2 years. So the issue before the party is whether the landlord is entitled to ask for enhancement of rent and also ask for eviction of the premises of the tenant. Since landlord's demands has not been heeded by the tenant, both parties are in dispute and both parties will assume go before a mediation. In the discussion in the mediation, we'll assume that the tenant agrees to vacate the premises by the end of next year. That is to say, instead of 2 years, he says that I am ready to vacate by the next year itself, within 1 year. But he seriously says, I will not pay any enhanced rent. So there are two issues here, namely enhancement of rent and eviction of the tenant. The enhancement of rent, there is no agreement or there is serious disagreement, whereas eviction, the tenant is ready to vacate provided he is given time till the end of this next year. Now, there is agreement insofar as the eviction is concerned. Both parties can sign a settlement and say the landlord agrees that the tenant shall continue in the premises till the end of next year, and the tenant agrees to vacate the premises at the end of the next year and quit and deliver the vacant possession to the landlord. They can defer the issue of enhancement of rent. It's open for the landlord to go and claim the enhancement of rent outside this forum of mediation. Or he can also say, since the tenant has agreed to vacate even earlier than what I had expected, I will not make the claim for enhancement of rent. So, agree to agree has resulted in a settlement, and sometimes that agree to agree also resolves an unagreed term, and that also helps sometimes to narrow down the scope of the dispute. Now we'll take one example to understand how facilitation works. There are two books on a subject of law before you. You are entitled to one out of the two. The choice is yours. You would like to take both the books, but you cannot, and you are only entitled to one out of the two. You are free to choose whichever you want. Now you are before me and I am your mediator. Now my job is to not to suggest that you take the right book or the one which is on the left. It's for me to explain the salient features of both the books. The authors of the books are different. Maybe I will have to say that author of the book is this, the total number of pages in the book is this much, the chapters covered in this book is this, the chapters covered in the other book is this, the number of pages is this, similarly the number of pages is this is latest, which is the latest edition, which is the older edition, what is the price of each of the book. And when these facts are placed before you, I will be doing the facilitation, and I am placing all the facts before you, and you would say, I would prefer to take book B rather than book A. Please note, here the decision to take the book is yours. You take the decision, and therefore you take the book, and you are always happy that you chose to take the decision and you have taken the book which you thought was appropriate and right. Me as a mediator, I have not suggested which is good for you. If I had suggested that A is good and not B, and suppose you found that B is good and not A, you would always say that because the mediator told me, I purchased B, otherwise I would have been happy taking A. Here, instead, I only facilitated you and you have taken the decision. You will always be happy, and you will take only the book which you've chosen. Therefore, you will always be happy with your decision and you will proceed. This is one good example of facilitation. In a facilitation, the mediator is not taking any risk. He is only placing the facts and allowing the parties to think. Parties think for themselves and they take their decision, and therefore mediation always ends with a settlement which is satisfactory and also easy to enforce, because the party is happy that it is his decision, his conscious decision to accept the result. We'll end this chapter. Thank you very much.